barrister. Traditionally, barristers are viewed as spending their time in court, arguing on their feet in litigation. That process can be time-consuming, it can be protracted, and it can be expensive. I don't spend all my time in court. I'm also a mediator. And through the process of mediation, I can help parties reach a resolution of their dispute without resorting to court action. And my role is one as a neutral. I'm an intermediary, a facilitator. I don't decide the dispute, but I help parties reach common ground and a way to move on. I can take on a more evaluative role. It's called early neutral evaluation. And through that process, I'll give the parties an early view on the merits. I'll often bring my expertise as a competition lawyer to that, and that can be useful to parties working out just how strong a case they have. Although I'm based in London, I do travel for mediations. I'll meet parties on their own turf, across the UK and internationally. And I've done mediations in as far-flung jurisdictions as Singapore and Stockholm. I can play the role of a lead mediator, where it's only me who's conducting the mediation, or sometimes as a subject matter expert, where specific understanding of competition law or regulation are necessary. I've also advised governments and regulators devise dispute resolution procedures where that's been used where they have a function of resolving disputes with commercial parties. So my understanding of how the dispute resolution process works, my experience of litigation, can be useful in helping parties and those defining the rules for dispute resolution work out the best strategy. I like to be innovative and creative. Usually when parties come to me, they've reached the end of their tether. They've had a long dispute, they don't know what to do next. They've reached an impasse. Often it takes the perspective of a neutral and somebody who's not been emotionally involved to work out the best strategy. I'm interested in people. I want to listen. It's not just about the law. It's not just about money. Sometimes a dispute conceals something much deeper, and I try to get to the bottom of that. That exercise isn't usually possible through the process of cross-examination in court. So I try to get under the skin of people because I'm motivated by what makes people tick. So that's my style. It's one of creativity, it's one of not closing my eyes to possibilities and really working out what's important to people. I'm a competition lawyer and regulatory specialist. In my role as a mediator, at one level, it really doesn't matter what my core expertise is because parties are looking to me for my skills on facilitation and working out solutions. But sometimes they do approach me because of my expertise, competition matters, regulatory matters. They can be very complex. There's technical vocabulary, there's industry lingo, there are technical aspects. So it can be useful to have somebody on the mediation who's conversant with those concepts. But I won't judge, I don't take a view on the merits, except when I'm asked to do so. But parties do find it helpful to have somebody who understands that technical area of law. Mediation is particularly interesting in competition disputes right now. At a general level, parties are increasingly including dispute resolution clauses in their contracts and providing specifically for mediation if it all goes wrong. The courts are giving robust encouragement to mediation. There's no requirement on parties to litigation to go through alternative means of resolution before they take their case to trial, but they may be punished with cost sanctions if they unreasonably refuse to mediate. And there are examples of that having taken place. In the specific area of competition law, there's a momentum to encourage private actions, bringing competition cases not through the administrative channels, a complaint to a competition authority, but through the courts. That's seen in the developments such as the EU Directive on Private Damages and the UK Consumer Rights Bill. But not all cases can be litigated, and there's real efficiencies and advantages in trying to resolve cases outside of the courts if the parties have a will to do so. And the UK government's encouragement of private litigation in competition cases is very supportive of ADR, including mediation. Some of the tried and trusted advantages of mediation in other cases are particularly apt when it comes to competition cases. For example, timing is an important factor. A mediation can be conducted and concluded in a day. Contrast that with lengthy drawn-out court proceedings. Complaints to a competition authority can also take many months, even years. Mediation can offer a more straightforward and timely solution. Mediation is confidential. That can be very advantageous in competition disputes where the parties want to take their issues outside of the mainstream litigation channel. They don't want their issues to be published all over the press. Mediation allows them to reach a solution without that being in front of the public eye. They can also avoid a precedent. There's no decision of a competition authority. That can be useful if they fear the threat of private actions for breach of competition law, so-called follow-on damages claims which follow in suit of a decision by a competition authority. The absence of a precedent can also be useful in cases which are very controversial, the issues are novel, and the parties want to avoid a decision that will be binding for the future. Competition cases can be very technical, there can be balanced economic arguments. Sometimes these can go on forever. The competition authority may not find that it's able to take a view on these issues without more evidence. Mediation offers a pragmatic solution to some of these challenges. An example of a competition case where I've mediated involved a distribution agreement. The dispute was all about whether the distributor could engage in parallel activity in competition with the manufacturer of the products. The parties were not necessarily seeking to terminate the agreement and really had incentives on both sides to continue. Had that dispute been brought through the courts, the options were relatively limited, but through mediation, they were able to resolve their differences, recognising that on both sides, the legal claims were not watertight, and they were able to secure a relationship going forwards. That might not have been possible had a complaint been made to a competition authority. It's just an example of the potential of mediation in commercial disputes where the parties do want to continue business with each other but have reached an impasse on a current issue. The decision to instruct a particular mediator can be highly personal. Usually it's not simply about technical expertise. It's about personality, it's about a particular mediator's style of doing business. I've been told that I'm energetic, that I bring new adrenaline to a case, When parties have reached an impasse, they're very tired, they've lost sight of a way forward, and they often need somebody to help them see a different avenue. I'm resilient. I'll stick with parties to the end. Typical mediations may be concluded in a day, but it's fair to say that not all are like that. And I will keep in touch with the parties to pursue other options if they don't settle on the day. Having said that, roughly 3/4 of mediations do tend to settle, if not on the day of the mediation, but shortly thereafter. I think that my experience does help on mediations because I've had a range of professional experiences during my career. I've been a solicitor, I'm now a barrister, and I've got economics experience. I've also advised regulators, so can see it from all sides of the table. And I hope that I can speak a language that business people, lawyers, technical experts can all understand. And my aim is to try to garner trust between parties when trust has broken down, when emotions are high, in a tense and sensitive situation. As a neutral, I try to rebuild that trust, to try to find common ground, and to try to help the parties see a way forward.